Hello, I'm Susan Van Scoyock. I've been a practicing psychologist for over 30 years, over 35 years actually, perhaps longer. And I am here to talk with Stephen, our data protection officer, about the general data protection regulations. My background is that not only have I practiced as a psychologist, I've also worked extensively in the court systems as a psychologist, and I have sat on the Membership and Standards Board and the Ethics Board, which has helped me know how a lot of these committees and panels are thinking about regulations.
I'm Stephen Van Scoyock. For the purposes of this today, I've been a data protection officer since the Data Protection Act went into effect roughly 20 years ago. 20 years prior to that, for those 20 years, I was responsible for documents at levels up to secret and the mechanisms we went through to keep those sort of things secure. Today, 4 decades later, nothing has really changed. So Susan and I will be discussing some of the questions that have come up in our webinars about GDPR and see if we can allay some of the anxiety about it. Susan?
Yes, so we called our webinars Don't Panic, and I'm hoping that by the time that you have watched this video that the anxiety will have subdued and you'll realise there isn't a need to panic. Simply follow some very fundamental principles about protecting people's privacy. And I'm going to actually go over to you, Stephen, and the structure of this video is going to be that I'm actually going to ask questions and play the psychologist, and the questions that have commonly come up, and you're going to be answering them. So principles, Stephen, what are the principles here?
Principles are important because principles make it possible for us to do our jobs without having to learn a lot of different things. One of my previous employers felt that principles were harder to teach than practices. In other words, it's easy to teach someone how to make a pot or how to build a car, but the principles that go behind that, if you know them, you can apply them across the board. And it's the same with privacy. The ICO talks about in the GDPR about privacy by design. And that means we need to stop and think about the basic principles of what we're trying to accomplish. What we're trying to do is keep people's data safe. We're trying to keep it secure, and we're trying to only keep it as long as we need to keep it. So we forget about the rules for just a minute about the GDPR and think about what we're trying to accomplish. So in your mind, you need to be thinking, what data am I in control of? What am I responsible for? If you took out your phone, you'd probably say you've got contacts that are customers, you've got emails that have come in, you may have notes that you've taken in some type of a synchronizing program. This is data that you're responsible for and that you have under control. So the next question you ask yourself is,
the basis for keeping data.
Well, your basis for keeping data. What are your grounds? What are your reasons for keeping it? And as you may know, there's 6 bases with the ICO for processing data.
That's the Information Commissioner.
That's the Information Commissioner's Office. Yes. And as you read through these 6 things, you might say, well, this might apply to me or that might apply to me. They have a very useful guide, interactive guide, where you answer a few questions. I've run a number of different scenarios for psychologists, and it always comes up with legitimate interests. That is, you are taking, collecting, and processing information that a reasonable person would expect you to be collecting, analyzing, looking at. Things like names, addresses, what the person came to you for, what your suggestions to this person are, what sort of notes you've taken, what's gone down into your notes. Additionally, you may be taking financial information so that you can get paid, which means you'll be entering them into an accounting package. Legitimate interests cover all this, and legitimate interests work well for psychologists because it's the most flexible of the bases. It doesn't require, and we're going to talk about consent from the ICO standpoint, not from the BPS, not from the HCPC, but from the ICO's perspective. You do not need to get consent every time you take a piece of information from your client. Under the legitimate interest basis, you are responsible for protecting that data and protecting the interests of your client. In exchange, your client does not have the right to demand that you remove that information, and they don't have the right to object. For example, if you write something down in your notes that they don't agree with, if you believe that it needs to be there, they don't have the right to object to it. Under the new guidelines and using legitimate interests, what they have a right to is the portability of your records. If they decide they want to go and see another professional, or even if they just want to go and get a second opinion, they have the right to ask for all of your records on them to take them with them. And that's fair enough, and you have a responsibility to comply with that request within 30 days, unless you have a very good reason not to. There is another aspect to this. You have to come up with two bases for processing data. The first one is for personal data, which is just name, address, telephone number, email address. It's personally identifiable, but it's not particularly sensitive. It's information they might give out to the storekeeper down the street. Then we have special categories of information, and that's information that would allow you to determine somebody's sex, their marital status, their sexual preferences, the status of their relationship with their spouse, and so forth and so on. And as a psychologist, you're going to handle that information all the time, and that's considered special categories. Again, legitimate interests appears to apply to this very well. You'll have to decide for yourself. You'll have to read those 6. You'll have to run the interactive guide, but my suggestion is that that's what you're going to come up with as being the best one for you. And of course, there are things you must do. If you're not already registered with the Information Commissioner's Office, you need to do that, because your protections as a data protection officer or as a processor of data don't exist unless you're registered with the ICO. So you do need to register with the ICO. There is no way around it. Even if you use paper records, you're going to be processing people's records. If you dial somebody's telephone number using your telephone, you are processing their information with a computer. So there is no way around it.
Let me come in here, and I've heard all sorts of things about I don't have to because I'm keeping paper records. That's the most common one. And actually, there, as you've just said, there is no way around this, is there? No,
there's no escaping it. Go ahead and register, and just consider it the cost of doing business. Now, under the GDPR, something that we didn't have to do before, you're going to need a privacy statement. Again, on the ICO's website, they have a guide for doing your privacy statement. I hope within a few days to have a template on our website that you can look at and use to form your own privacy statement. You'll still have to answer the questions for what's applicable to you. The ICO doesn't expect it to be perfect. It's going to be a living document, and again, it's about principles. If you're following the principles, and we'll get into that in more detail in a bit, if you're following the principles, you're protecting people's data, the ICO is not going to worry about whether you might have a clause missing from your privacy statement, and neither is your client, because they know they're protected.
Okay, and I think that here, one of the things that I've often been saying to people in supervision is that if you were already following the principles of the Data Protection Act, which you should have been doing now for years, a lot of this will not be difficult for you. Because it was about protecting people's data, or as I like to call it, protecting people's privacy. We've been doing that, and we do that as part of our profession. It's ingrained in us. We were then having to do more under the Data Protection Act. So if you've been following good professional practice, none of this should actually be too onerous. It just seems frightening.
It does seem frightening, but remember that the big guns are actually out for the big companies who've been abusing data, as the recent experiences with Facebook and Cambridge Analytica have revealed. We still have some things we need to look at. I've run into psychologists who get a little lax and they leave records sitting out on their kitchen table, or in their bedroom on a bedside table, or they get out of their car and leave their computer in the hatchback behind the seat, because they never think that the worst might happen. We've had cases where psychologists locked the doors to their office and went home to return to find that their offices had been broken into. And fortunately, their computer was locked away, and the things left out that might have been taken that would have been a security breach, they weren't interested in. They were looking for easy money. You should always be aware of where your data that you're responsible for is. Don't leave it in the car. If you walk out of your office to go get a cup of coffee, you put it away. You lock it away.
And log out.
And log. Remember to log out.
We'll
talk about that.
We'll talk about that.
But do log out.
There was an example. There has been an example this year in 2018 of a senior police officer leaving records in the boot of his car over a long bank holiday weekend. And he is facing all sorts of disciplinary action because he forgot that whilst he's put it in the boot of his car, it's generally not acceptable to just leave sensitive private data for an extended period of time. And what happened was his car was stolen. So that's why he's in trouble. Right, we're going on to the how-to, the real nitty-gritty, which is where most of the questions come from.
It is.
Shall we start with storing records?
Yes. We have at our disposal really effective ways of storing our records. Unfortunately, we're often so busy and new things are happening and we're buying new gadgets and we're trying new apps and we forget to actually make sure that we've locked everything down. So the first thing, the most basic principle, is to make sure that your computer, be it a Mac, be it a Chromebook, be it a Windows machine, is to make sure that you have a password and that it is encrypted. And on most computers you will have to go in and set that in the settings, and then it will begin the process of encrypting the hard drive. You also have to remember on most of them to log out when you're not using it, because then that locks everything back up and leaves it encrypted. It basically disconnects the key that's necessary for decrypting the data. It's easier on your tablets and your phones. Most of the newer ones, the Android and the iPhones, if you have assigned a password, and I recommend at least a 6-digit or 6-character password, or your fingerprints, or both. As soon as you set that, it encrypts all the information on the device. And you need to make sure that it's set to lock. Some of them will unlock when you're carrying them on your person. And it can't tell who's carrying it. So if somebody snatches it from your hand and it's unlocked, it's going to stay unlocked and they'll have access to all the data on there. But the actual physical process of keeping data like that secure is pretty straightforward. There have been questions about storing it on a cloud. iCloud, OneNote, Dropbox. These are all fine. The ICO is not saying that you cannot do that. And in fact, the security precautions in place for those are better than any I could come up with on my own. If there's a breach, it isn't likely to be there. And if it is, it's not likely to involve your stuff.
We've got storing records, clinical records versus administrative. And what does that mean, clinical versus administrative?
Professionally, you're a professional psychologist. You will have records that relate to your client's mental health, their family relationships. So you're protecting not only the information of your client, but also the information of people they know. Perhaps job information. You may be privy to business information that would be tantamount to insider trading if you were to release it. So you're privy to a lot of information. And that would be clinical information, and you're going to have to make a decision on how long to keep it, what kind of information it's going to be. Administrative records would be your appointment schedules, your billing information, your accounts.
It's not what I would call the personal clinical
No,
stuff.
Usually it's not going to be.
It is purely billing and appointment dates. The stuff that you might have to go back, and in fact you said for tax purposes and audit your accounts or something.
Generally, those of us who run accounting systems, they run in perpetuity, and the only information we ever actually have with the clients in there is their name and their email address and possibly an address or a telephone number. This is all personal identifying information, but it's not special category information. But you need to distinguish between the two of them.
May I come in?
Yes,
on
absolutely.
The clinical? Because one of the things I'm often asked is, so how long? Do we have to keep the clinical records? I'm not talking admin now. Clinical records for 7 years is the most common one that I'm asked. Actually, I think that you will agree, Stephen, the length of time that we need to keep the records is what we deem as a professional is what's pertinent to the client, useful to the client. I think you've got a better phrase. It's gone out of my head. But anyway, it's when it's fit for purpose. Is it useful? Is it still clinically relevant to keep this information? The Data Protection Act and the GDPR is urging us to think about, does it still fulfill a purpose to keep these clinical records? So there are psychologists I know who will inform their clients at the very beginning of therapy, in a way as part of their privacy statement, that they will only keep the records for 4 weeks or perhaps 3 months after the completion of the final session. And if there is no, and if they don't object, if they don't ask for you to keep them, there is actually there is an argument that there is no need to keep them for year upon year. Actually the threat to someone's privacy is greater than keeping them in case at some future unknown date that has not been discussed with the client that they might come back.
Yeah.
So you've got to make an individual decision, haven't you?
That's right. As a professional, you have to make that decision, and you have to decide that keeping the records outweighs the risk of what might happen if those records are compromised. Mm-hmm. The ICO wants to see you get rid of records when they're no longer needed for the purpose that they were intended. You can't come up with a new purpose for them after you've acquired them, and you can't come up with a new basis for processing them, like you're going to write a book or something like that. Technically, you can't do that. So you have to use your judgment. A person who comes along to you, they have a momentary crisis, they see you for 6 weeks or 10 weeks and they feel much better and they move out of the country and they get married, there really isn't any point in you keeping their records. At least, I mean, that's just an example, but it doesn't seem likely you would need their records. If you have someone who already has a history of returning to healthcare providers or mental health care providers, and going between experts and wanting records to be transferred to this person and into that person, you may make a knowledgeable, educated decision that those records should be kept for a while. In any event, the ICO wants you to be transparent with your client as much as possible about what's going to happen to those records. You could ask your client, do you want me to keep these records or do you want me to get rid of them? If your client says to get rid of them, well, that's an easy one. You just get rid of them.
Yeah, I mean, I've certainly seen this, and have written on our website that I see this as increasing the amount of collaboration between the psychologist and the client about the holding of records. I personally think this is a good thing. Another point is that admin records, I think in the past you've mentioned 3 years?
Typically with tax records, the HMRC wants you to hold on to your financial records for 3 years. You may need to hang on to them longer than that. You may choose to hold on to them longer than that, but in any event, you'll need to take care of them for that period of time. And as anybody who does accounts knows, it can be difficult to get rid of a client's name in your accounting records. And if you come up for an audit, the HMRC can ask some very uncomfortable questions about why there's a blank in your records. And you hear a number bandied about 7 years. That's something that's come up with lawyers because generally you can only file a claim in the county courts or civil courts up to 6 years after an event took place. So 7 years keeps you covered, but that's not the business that we're in. We have to make a decision based on what is best for our clients. And remember what I said about legitimate interest. Not
based on what's best for us,
that's
but what's
right.
Best for the client.
It's best for the client.
There is a sort of grey area at the moment. It's always a grey area as far as I'm concerned as a psychologist, and that is, what about the records of children that we see? So how long do we keep records for children? And there are all sorts of things that have been suggested and are currently practiced. We keep well, I don't, but organisations keep records up until a child is 18. Some of them keep them up now till they're 25. And I think that yet again, this is down to the professional psychologist using their knowledge of the work that they're doing with these children as to whether it's justified to keep the records for that length of time. Would you agree? It's about justifying decisions.
It is still
isn't it?
about justifying it. I think choosing an arbitrary number like 18 or 25 is probably not consistent with the ICO's approach. The ICO has discussed children, has discussed if the child is old enough to perhaps understand what's going on, that you should be discussing with them the protection of their records and what's likely to happen to those records. At the same time, if they're under the care of a guardian, such as a parent or someone with power of attorney or a solicitor or a carer of like a social worker or something like that, they are making decisions for that child. So once again, you're treating them as an adult in terms of records, and if they say we don't think these records should be kept past his or her 16th birthday, then that's pretty much what you've got to take on board. You're being told by a responsible person, what they want done with those records. This is one case where I feel you should definitely go to the ICO and either read the GDPR, it does have a section about children, and make sure that you understand it. If you don't understand it, write to the ICO, make a telephone call. I've had a number of dealings with the ICO over the past 20 years, and I've always found them to be helpful, to be completely clear, and actually rather pragmatic about things. So the GDPR is not about getting caught up in the semantics and being pedantic about the rules, because the rules aren't the point of the GDPR. The point of the GDPR is to protect your client's data.
I think that's covered it. You sent them back to the ICO, which is always a good answer. All right, sure. Are you ready to move on?
Absolutely.
Okay. Using emails. Well, a frequent question is about using email. Can we use our whatever email provider? Can we use Gmail? Can we use I don't know, iCloud? Can we use I've forgotten the Microsoft one, Outlook? It doesn't matter which one it is. No. The question is, can we use emails? And I think your answer is going to be yes, isn't it?
Absolutely.
Okay.
The ICO has not said that you have to get a contract with Proton 8888. We haven't said anything about first-class mail, and it's far more likely to go astray than an email with confidential information and credit cards and bank statements and things like that, and they do all the time. The point is that your emails that you send out should have a minimal amount of information in them. You should try to avoid having any special category information. Now, your client may write to you and explain
with their life history.
With their life history, they may tell you everything, and I know because they do it right through our website, and that implies a certain level of trust. They trust that you're going to receive it, and you probably are, and they trust that you're going to handle it appropriately, and of course you are. However, when you reply to them, I think it's good practice to reply with a clean sheet of paper. And do not copy all this material back to them. Rather, take that material that's in that email. If you feel you need to keep it, cut it out of the email, drop it into Evernote, put it into OneNote, put it wherever it is that you keep your notes, and then carry on communicating with the person. Get rid of the email. Now,
so you're saying, I think, whatever they send to you, which is usually the most revealing information, personal information, take that, if you feel it's pertinent, if you're going to be working with this person, move it to what I would call their client file. Yep. Whatever program you're using, move it to their client file where it's safe and passworded and all the rest of it, and then delete it from your email inbox. Delete. I mean, I have a very long email inbox that I am trying at the moment to go through and delete.
Well, I think that I would elaborate here and say that your emails, if you followed the principles, if you have passworded your computer, they are as protected as anything else on your computer. The difficulty with emails is that it's so easy to misdirect something. For example, we all know about autocorrect. and autofill. And you start to fill something in and you look at it and you go, darn, that's not what I wanted in there. But if you hit the send button, it's gone, and it may be gone to the wrong person. And that in itself is not necessarily catastrophe, but it is a breach. And we've all done it, okay? We'll admit it, we've all done it. But by removing it from your emails, you've reduced the likelihood that it's going to happen to that particular one. Now, be aware that a lot of email providers, and I'm not mentioning anybody, but like Gmail, Google actually they scan these emails for information so that they can enrich your advertising experience. And you might want to choose an email provider that doesn't do that. That's up to you. I have no evidence that they've done anything improper from having scanned it, but there are other email providers that are perhaps a bit more secure. And if you have your own website, I would suggest that you run your emails through your domain. It's not that hard to set up. They usually have a control panel, and normally their tech support people will walk you through setting up your emails so that you can send them and receive them and have pretty much complete control over what's happening to them.
Next question, sending files via email, and this is pertinent for sending any client information, and I'm going to bring in my sort of topic area, including expert witness reports.
Yeah, this is a case where most software has kept up with the times. Word will allow you to password protect a document before you send it.
So will Pages.
So will Pages.
Yeah.
And if you want to go further than that, I'm not sure that Word will do an encryption, or if adding the password does actually encrypt it. I can't say. But if you export it as a PDF, you can go into Adobe and you can not only password protect it, you can encrypt it. And of course, PDFs are much more difficult to manipulate than Word files anyway. So that would be that's the path that we normally use, is to encrypt a PDF file and send that on.
With a password.
With a password. And there's a lot of elaborate ways to make sure that you get a password to somebody, but we're not dealing with material of national interest. So if you simply speak to somebody on the phone that you've spoken with before and you know who they are, I think it's quite reasonable to agree a password with them that you'll always use on their documents. And that way you can go ahead and send the email and know that they'll be the only ones who can open it.
May I? I mean, this sounds so obvious, but don't send the file in the same email that you write down what the password is to access it. That's what if for any reason you've been doing that already, then stop immediately. The password and the file with the email, they need to be separate.
Well, and in fact, I wouldn't even suggest sending the...
You wouldn't, would you?
I wouldn't send the password by the same...
You like the telephone.
I like the telephone.
But it should be a different medium, is what I've been told.
Yeah, it should be a different medium. You could do it by text, but again, texts are not necessarily always reliable. But most of the time this works okay. There are also email providers that are secure, and you could do documents that way. Dropbox will allow you to create a password to get into a folder, so you can upload it to Dropbox. A lot of times these reports are fairly hefty tomes anyway. So you could upload it to your Dropbox account and send the link to the person and then provide them with a password to recover it. These are all reasonable ways. We're not dealing, like I said, we're not dealing with national security level data. We are dealing with stuff that could be embarrassing, could be humiliating.
So we need to be careful.
So we need to be careful.
As careful as we would with paper records.
That's right.
Just basically look after our clients. Yep. It's reasonable steps, isn't it? It's reasonable, not extraordinary steps.
No, it's reasonable.
Yeah. And paper records, I wrote this down. You can see that we're going for a script. Paper records, keep them in a folder, keep them in a locked filing cabinet. It's the basic practices that we would have done before, but GDPR is going to expect you to have made provisions for your paper files to be absolutely secure.
Yeah, and if you're dealing with a lot of paper files, I mean, we try to run a paperless office, so when we get paper files, we scan them and put them onto a secure device. When you get rid of them,
shredding,
you need to shred them, and you need to shred them with a cross-cut shredder, because we now have software that can put together strip shredded documents faster than you can imagine. Not that anybody would try to do that.
or use a service.
Or use a service. Many of the office supply companies will take your documents for shredding. We use services here in the US. We have services in the UK. In fact, in the UK, we buy a bag for £5. We fill it up, we take it, they shred it, and they give us a certificate that says that it's been shredded. So it's worth the peace of mind to do that.
It is for us. Well, at least we have found it is for us. Okay, next one. Ready?
Yeah.
Video conferencing. One of the really common myths, because in fact if you go to our website, and I'm going to give you the website now because we've mentioned it several times, our website is www.vanscoyoc.co.uk. It's our name, www.vanscoyoc.co.uk.
Of course, they're watching this on our website.
That's true. That's true. Okay, duh. But one of the most frequent questions, and one of the ones I wrote under the myths of GDPR, is that you can no longer use Skype or FaceTime or equivalent to do video conferencing with your clients. It's not true. Shall I continue as to the problems, or no? I'll carry on. You can use them, but what you need to do before you start your series of consultations via video conferencing is to talk with the client or explain with to the client via email, in person, that there are difficulties with services such as Skype and FaceTime, and they are that you leave what's it called?
Well, you leave a signature.
You leave a signature. You leave a signature, and in fact what you leave, and you will know this if you already use them, because it will say at the end of your call that whom you have talked to and how long you have been talking to them. So the client needs to be aware that if a family member or a colleague accesses their computer, they may well see that they have talked to me, so for example it might say Susan, for an hour, and if there's a difficulty in the relationship, then there may be jealousy, there might be a big argument, and your client may not want anybody to know that they're actually spending time talking to you. So that warning, so the warning of the risks, needs to be given to the client. Now, if the client is very happy to consult with you via Skype or FaceTime, they are agreeing to do so, and you are allowed to do so. We use a service called Zoom, and anybody who came on the webinars will have tried that out with us, and it leaves no record on either the client's computer or in fact mine as to whom I'm speaking to once the video conference is over. There is no trace, that's the word I was looking for, there is no trace left on the computer.
Now, I will elaborate on
Please
this
do.
with Skype and FaceTime. I've had extensive correspondence and verbal communication with the ICO over the past 5 years to verify that their stance had not changed. They don't have a problem with it with Skype. They do say that you should have an agreement with the provider about breaches and history, but this is the real world. The real world is your client has agreed to do this interview by Skype. You've agreed to do it by Skype. You're both aware. I will also point out that a number of NHS trusts are now using Skype for CBT and
GP consultations have just been recently introduced.
What Susan mentioned was Zoom. Zoom is available free for sessions of less than an hour, which may suit a number of psychologists right down to the ground. In other words, each session with each client has to be less than an hour, and I think there may be a limit to how many people can be in a session. Now, with the paid account, there is no limit, and you can have up to 100 people attending at one time, which is pretty big for group supervision, but it's something to consider. I think that's really it. And you'll hear a lot of people talking about HIPAA compliance. And the only reason I bring it up is because I hear it all the time. HIPAA is an American invention. HIPAA is for healthcare providers who are filing insurance claims.
In the U.S.
In the U.S. It has absolutely nothing to do with the U.K. And it doesn't have anything to do with people in the U.S. unless they're actually filing insurance claims with an insurance company.
So that's it.
So that's that.
All right, there are two more things that we've got listed here. I think that we thought that it was worth elaborating on the word consent and its different meanings to clinicians as opposed to the GDPR.
Yeah. Do not confuse the GDPR with your own professional organization's terms and terminology and nomenclature. It has its own language. Under the ICO, consent is one of the 6 bases for processing, and this is a case of I send you an email saying I would like to put you on my mailing list for candies each month, and if you will tick this box and send it back to us, we can add you to the list. That's what they mean by consent, and that's the first of the basis for processing. It's a type of permission to use your personal details, but only as long as you're comfortable with that arrangement. As soon as you say stop that, they have to stop doing it, and they have to remove your details from it.
And it's usually associated with marketing, isn't it?
It's associated with marketing.
Which is what makes it different from this clinical work that we do.
And it has absolutely nothing to do with when your client comes to you and says, you say, well, I need to be able to talk to you about this, this, and that, and they say, yes, that will be fine. That's a different type of consent. We're not talking about the consent to process data. We're now talking about their consent to talk to you, and you may have a privacy or a confidentiality agreement that is specific. It's like a contract between you and your client. In fact, I'm going to call it that. It's a contract, and that is separate and apart from the ICO. The ICO is your responsibilities to the public, and it's really just a starting point. There was something I was going to say about that, but it might come back in a minute. All
right, well, if it comes back, we can come back to it. But we're going to finish with your comments on the privacy statement, which we are all required now to have. And I'm going to say, if we were following DPA, we were almost there.
Yeah.
We were almost there.
If you're already in compliance with the Data Protection Act, then you're doing pretty well as far as the GDPR goes. Did I say that right?
Yeah, you did.
Okay.
Just fast.
Just fast. Okay. Right. The privacy statement basically is everything that we've just been talking about, laid out in a statement for your client so that they know that who you are, who your data protection officer is, I know what I was going to talk about, what your address and contact details are, including an email address, and because people can make a data subject request to you through any means of contacting you, even verbally. They can call you up on the phone and say, I want a copy of all of the records that you have on me, and you have to comply. You have 30 days to do it, and you can't charge them for it. Used to, it was 40 days and 10 pounds, but you can't do that now. Okay? Then you move on to the types of information you're going to process. And when I talked about principles, one of the questions I said you ask yourself, what kind of data am I holding? Okay, so it's going to be sexual preference, address, children, marriage, medical records, educational records, social records. As a psychologist, you could get all sorts of records. Keep it simple. Just make it clear from what you say that it could include a whole lot of different kinds of records. Okay. Then you proceed on to your basis. I'm going to suggest that you look seriously at legitimate interests. And I'm going to suggest that you use the interactive guide on the ICO website. Just Google it and it'll pop up. Don't waste your time on other people's websites because the ICO is the one that counts. Answer the questions, and at the end, when you click submit, it will give you an instant response as to what basis they believe apply to you. And the thing is, this is not about rules. They're not trying to tell you what to do and how to do it. You are saying, this is how I want to handle the data. I think this is appropriate for us. And if you're following all the principles of good data protection, you're not going to run into any trouble. You carry on through this list. They want to know what types of special category information you might have. They're going to want you to state how long you keep your data. And you're going to have to be kind of vague. You could just say, we will typically keep your data as long as we need it to provide you with the service you have requested. And then you could say, we will get rid of your session notes 4 weeks after you leave if you choose to do that. Always leave yourself some wiggle room though. Always don't be absolute. Don't say we will never lose track of your information, because you can't promise that. And don't say we will always destroy your records after 4 weeks, because you can't promise that.
And you might be on holiday.
And you might be on holiday. You might get a letter from somebody's lawyer who says we want all of these records. You might get a court subpoena. There's all sorts of things that can happen. So you're just kind of giving a guideline to your clients so that they know what you're going to do. I won't labor through the rest of the points on the privacy statement. You can go to the ICO's website, and they have a tick list on what you need to include. And quite frankly, you could take their titles, put them in a Word document, fill in the blocks underneath, put in your own information underneath, and go all the way to the bottom and get a perfectly usable privacy policy.
And you were actually going to put one on the website.
I will put one on our website so that you have an idea of what to do, and you can even take it and use it. If I can put it up there as a Word document, I will. Otherwise, you can just copy it from the website and plop it into a document. What I was going to talk about, a question that has now come up in nearly every venue we've discussed this, is shared responsibility as a data controller or a data processor. You can write up any agreement that you want, but if it contravenes the ICO's rules on the GDPR, it isn't going to hold water. A number, apparently, have had dealings with lawyers now who want the lawyer to be responsible for providing for any data requests. It doesn't work that way. You can see Article 26, Section 3 of the ICO's GDPR, and it explicitly applies to this. It says you can do this. However, the data subject has the right to come to you, regardless of other agreements that you have, and demand the records. They can also hold you civilly responsible if there has been a breach. That's sometimes called jointly and severally liable. So if you and a lawyer were both responsible for somebody's documents, they can come after either one of you or both of you if there is a claim to be made. So do not think that you can write an agreement that gets you out of responsibility, even for the administrative side of this. You are responsible.
Okay.
Did that sound stern enough?
It sounds very stern, but I think it's something that needs to be very clear, that ultimately we have to make the decisions. We have to be able to justify our decisions about what I'm still going to call private information, the data. We have to make those decisions, and we have to be answerable. I think it's very simple. I've often said this is like almost everything else we do as psychologists. We have to be able to show why we made the decisions that we made. So we have to be able to justify them. If you can do that, then actually you have thought this through. If you do it because someone says, well, Susan said, that's not good enough. So I'm being stern too here. I'm really putting the responsibility back on your shoulders. Now, we started this with saying don't panic, and I am going to finish with saying don't panic, including the fact that whilst the GDPR comes in on the 25th of May 2018, the ICO itself recognises that we may still be working towards compliance as we go through its requirements and look at our own practice. So the world is not going to end at midnight on the 24th of May for psychologists who haven't already sorted all this out. Agreed? Agreed.
Business is not going to stop just because of this. I would suggest that you visit our posts page on our website, where I've just recently written about the principles of this, and I feel like you can pretty well distill this down to 5 or 6 questions. And if you can answer those 5 or 6 questions to your own satisfaction, then except for filling out a privacy policy and every once in a while looking and seeing if anything has changed, you're okay.
Every 6 to 12 months, you should revisit the questions
Yeah,
in case your business has changed.
In case it's changed. The one thing that's been added is a burden of some record keeping. You need to know when somebody gave you consent. For example, if you're doing a mailing list and somebody signs up on your mailing list, which incidentally we have on our website, then you need to keep a record of them signing up on it. That way you have proof that they have signed up for it. I have found in recent audits, yes, we have been audited by the government in various things and ways, that when they ask for something and you can produce it, even if you're not 100% compliant, they're very satisfied with that. And that's the way the ICO will be for us smaller people. The ICO is a complaint-driven organization. They are not out pounding the streets like the TV licensing people, hoping to catch somebody out. They've got far too much to do with Facebook and WhatsApp and all the rest of them. If you're responsible, as you are professionals, you're not going to have any problems. Nobody's going to complain. And even if they do complain and you missed something and you just did it wrong and you put it right, the most you're going to get is a letter saying don't do that again. And that's it. They're not going to fine you 4% of your global turnover or 20 million euros, whichever is higher. It just doesn't work that way. So I hope this has been helpful.
Yeah. If you have any questions, there is a way of contacting and sending us a message on the website. So if there are further questions, do please contact us. And I just hope that this has been helpful and allayed the fears that have arisen out of the myths around psychologists and GDPR.
Yes, you can send us an email from our website and it doesn't go onto a mailing list. There's another place on our website where you can fill in your details and it does go onto a mailing list, and we'd love for you to go there. Thank you very much.
Thank you. Goodbye.